Mr Chair.
I call David Clendon.
Thank you, Mr Chair. Mr Chair, as we clearly understand, people giving commentary on this bill, that the primary purpose of the bill is to extend the permissible period between parole hearings when it's the judgment of the board that offenders are highly unlikely to be proven to be eligible for parole. So I'd just like to put a little bit of context around that, and it picks up on some commentary I heard a few moments ago, and I think it's worth reminding ourselves of the value of parole and the importance of having parole available as a tool, as a management tool in a sense. It's been highlighted in recent days by the phenomenon, if you like, which has now got some public traction, of people who have seriously offended overseas, New Zealanders who have been sentenced in many cases to long jail terms internationally, who are then complete their term, put on an aeroplane and dropped back in New Zealand. That is something that has existed recently. There's one particular case that's excited some public commentary. I actually share the concern of those people who think it's entirely undesirable that a person does a long term in prison, is literally taken from their cell to the airport and effectively dropped in New Zealand with no further controls, no constraints on them, no ability for the state, for the community to impose any management on them. I don't think that the solution to that is a registry. I think it, as I say, the phenomenon, for want of a better word, does highlight the importance of parole and the value of parole as a means for us to facilitate the transition from custody back to reintegrate people into the community. And I do think that, as our colleague has just stated, the Greens, we would disagree actually that the correct balance has been struck in this legislation. We're not convinced that it is that the provisions in it are actually the optimal provisions. We think that there is, frankly, well, there are three key drivers of the bill and of the provisions that are the technical provisions that are contained in it. One is cost saving, and yes, it is expensive to running the parole process. Another is the importance, the value of keeping management, keeping people optimally managed, if you like. I think it's true that, and of course, protection of victims to prevent the re-victimisation of people, and I do think that that's overstated. Dealing with that first point first, I think the cost-saving argument is the least argument put forward in this legislation, and for the reason it's actually a very weak argument. I investigated with some QWAs in an earlier process to ask the question, what was the methodology behind establishing the numbers we were given, determining what the cost savings were, the reduction in the likely number of parole hearings. And frankly, there was no methodology. The answers we got back indicated there was a best guess made as to the percentage reduction in parole hearings that would be facilitated by this legislation. And then, as is the beloved of economists, from that point on, having established a very shaky assumption, there was some sophisticated formula applied to that assumption that generated what looked like some defensible numbers. So I think the matter of cost is a very weak justification for this legislation. It's not proven. You'd only, if you save the cost of a hearing, we think is around $1,000. Give or take, it varies depending on circumstance. So you might, if you, for every 90 hearings that are not held unnecessarily, that's 90 grand. You've only got to end up as a result of that process with one inmate serving 1 year longer in jail that they might not have otherwise, and that cost has gone away. Round figures, but I think the current cost of keeping somebody incarcerated, 95, 97,000 to that sort of figure. So the argument that we are protecting victims, a very powerful argument, and yes, we do want to protect victims. We don't want people constantly re-victimised. We have heard from individuals of the stresses imposed on them because they feel obliged to attend these parole hearings, which in some instances are coming around fairly regularly. In fact, it's only a very small percentage of people who take the opportunity to attend the hearings or to be involved in them. There is, I think, a popular misconception that the victims are obliged to face the person who offended against them, and that simply is not the reality. At no point is a victim obliged, Mr. Speaker, Mr. Chair. Thank you, Mr. Chair. At no point obliged to confront an offender. The Parole Board is much more sensitive. They manage these people very carefully, but I think the key point is that only, I think, from memory, and I am relying on memory, unfortunately I don't have the note here, but I think something like 3% of people of victims actually attend Parole Board hearings. And with all due respect to those people, 7%, thank you. With all due respect to those people and their obvious concerns, I think it's possible to overstate the extent to which their attendance at those hearings actually influences the decision of the Parole Board. And I do say that with greatest respect to the Board and to the victims. Clearly, the Parole Board will expect that somebody who's been the victim of a horrendous crime, of the loss of a family member to a murder, they've themselves been assaulted or grievously harmed, of course they're going to want that person to stay in jail for the longest term possible. And I do think that the statement that, the assumption that that carries significant weight with the Parole Board is possibly overstated. Sir, our compelling concern with this legislation is that the process that's set up around these so-called, what we no longer call milestone events, relevant activities, the bill rests on an assumption that inmates will be motivated to complete the various programs, whatever it is that the board says they need to complete before they can be considered for release, for parole. We know, because corrections have told us, that they are already struggling to schedule inmates into available programs. I have many letters in my files, and I'm sure other MPs have similar letters, from inmates who are saying, look, I want to get onto this program. I know I need it. There's a benefit to the inmate and to the wider society for these people to do these programs, and they simply can't get access to them because the programs are oversubscribed. The scheduling difficulty, corrections have said, is partly a technical one. They don't have the IT facility, and it's not on the horizon that they will get that technical IT capacity to facilitate that scheduling. I support the work that it's been done by the previous minister, and I'm sure this minister will continue it, to broaden the range of programs available. I am pleased that the government, over the last term particularly, actually started talking more the language of rehabilitation, reintegration. There is more goodwill being displayed towards dealing with these people, healing them, dealing with the underlying causes of their offending. But it's no point putting these relevant activities requirements into legislation if, in all good conscience, inmates are being denied access to them because there's simply not the infrastructure behind it. Build the infrastructure, create the capacity within the system to deliver these very positive and helpful programs, be it drug and alcohol, be it mental health issues, be it basic literacy, be it work skills, whatever it might be. Create that infrastructure first and then put the obligation on inmates to pursue it. So we think that whilst there's some good intentioned aspects and provisions in this bill, underpinning it are some false assumptions, we believe, some false expectations. And we do know that the requirement that inmates that inmates must first accept guilt as one of the provisions before they can get into some of these programs. On the one hand, yes, it does oblige people who have offended to confront their offending and honestly accept that they do have a debt to pay. But it's also, there are such a thing as people in prison who are innocent and who continue to maintain, or rather to express their innocence And this, as a number of submitted pointed out, the provisions of this bill put those people in a very difficult position. They are actually forced to lie, despite the fact that they genuinely believe themselves to be innocent. And there are examples we know where we have incarcerated innocent people. It doesn't happen that often, but it does happen. And it puts those people in an untenable situation. And it's also contrary to our own Bill of Rights that said people ought not to be compelled to make those sorts of false confessions, if you like, or to implicate themselves when they know very well they actually have not offended. The likelihood of this bill having significant...
Call Todd Barclay.
Thank you, Mr Chair. As a